Hello and welcome to this new episode of Upclose with Upward. Today our guest is Sai Priya, and this is one of the first of the many conversations we'll hopefully have with her on this podcast. Sai Priya is a doctor and a student of law, and her interests lie in the realms of Hindu art, culture, law, and religion. Welcome to the show.
Sai. Thank you for having me.
And we'll start with, the most cliched questions that you must be hearing all the time, which is, after medicine, why did you choose law?
You put me on the spot here, but I think during COVID, I was preparing for my USMLE, which is the residency program in the US. And that was around the time when I started reading a lot. I started writing. I wrote for Op India. I wrote a bunch of articles on colonial history and all of that. And I think my mind was somewhere very altered. And this was the time I met Sai and worked on his books with him. And he said, "Why are you still in medicine? Like, just jump to law." And and every time he would talk to me, he would say the same thing, which is just jump. And eventually I was convinced. I thought, it makes sense for me to pursue my passions. And I don't know, kind of do the things that I want or be the change that I want to see, sort of thing. But also, I feel like somewhere I wanted to use my skills for something that I really want to do and felt strongly about. And I think I've kind of found that. I hope to go far. Let's see. Hope for the best.
Yeah, all the best for that. And I've experienced that myself also, because Sai makes it sound like the legal fraternity is always having a party or something.
They're not. They're not.
Okay. So this is very recent then, this switch, right?
Yeah, 3 years. Yeah, 2 years.
Okay.
Yeah.
How are you liking it?
I love reading legal philosophy, Hindu law, which I've been reading about for the past year. A lot of interactions between colonialism and the law as it is in India today. These are things I read and write about as personal research projects. I'm trying to get some stuff published, but at the moment, it's just mostly me just consuming all of this.
Right.
And I think that's
I must compliment you for being one of the sharpest and the most brutal handles when it comes to speaking the truth. So
Thank you so much.
I don't know if that you will take it as a compliment, but yeah, this is what
it
I
is
feel.
what it is.
So we'll jump into your newfound passion, which is law, and tell us more about the historical development of law in India as we know it, right? From the times of ancient India to now. If you could give us like an overview of how things have changed in terms of how society is organized, what is their relationship with the law, and if we can imagine law in the same way that we experience it today in the past.
So the short answer is no. It wasn't anything like this. I feel like, as from my understanding, first there is no word for law in Sanskrit. It is just dharma. So there's different aspects of it, but there is no real word for dharma as such, because it was like an inextricable part of dharma and part of polity and how the state is set up. But very different from it, because it's not kind of prescriptive in the same sense. It's more duty-based, it's more individual and community-based,
right,
rather than centralized. Of course, this king had the power to issue edicts and all of that, nyaya and whatever. But that was within the frame of what he could do, but it was nothing like the way it's set up now. So I think the origins of the current legal system would be obviously Western and Westphalian, but if you trace it back to, say, ancient Greek and Rome, where they had, again, the first conceptions of democracy and the democratic system came with this sort of conception of law. And at the time, it was just religious law. But for the most part, again, they had a huge divided history in Europe, like monarchies, they had totalitarian and authoritarian regimes, they had a lot of different types of political systems, and with that comes, I think, the systems of law. But the modern system, I guess, after the World Wars and the League of Nations was formed, and then this entity of what a sovereign nation is, and with that came like the democratic setup, and with that is a package with law, and I think it's been it's a radical shift from what we had before, which we'll get into kind of the details later on, but it becomes so I think that's where we're at. The intricacies again of how these systems came to be, like what was the interaction like with various foreign rulers successive foreign rulers that we've seen. So based on this, I think it's evolved in such a way that it's unique to our condition here.
Right. So a lot of people say that we have progressed to the state of modern law now, and that implicit in that statement is the fact that we have become better. Do you subscribe to that view? And you can be candid. It's not a scholarly question. It's just your personal.
So again, this goes back to how the Western the Western powers frame civilization and all of that. They think, or they frame modernity as progress and as something positive always, which is probably not the case. Again, maybe it's better for economic interests and better for global trade and globalization, but we don't know if at the individual level it's actually progress in the sense of betterment. So I don't really think there is betterment. I think for better or worse, I think both systems have their own merits. Again, our system is set up in such a way that there's kind of collective movement towards a certain goal. There's an inherent worldview and perhaps a very religious worldview that is imbibed into law itself, so that individuals can maximize their kind of interaction with life, like how do you make this life, and how do you,
like the pursuit of Purushartha.
Yeah. So exactly. So yeah, so how do you pursue? So in pursuing these goals, you kind of maximize your existence here, because we believe in eternal, or the world being eternal, and then all of these. So all this philosophy is embedded into our systems, and we follow what is called Tonic law, which is CHTHONIC, which is law based on natural order of things, human nature. So Dharma Shastras embody and prescribe things based on the qualities of an individual, the qualities of communities, natural order. So it's kind of a natural law system as opposed to what we call positive law, which is what the Western system is.
Right.
And positive law is top down. It's framed by the state and imposed in a sense, but not the natural law isn't, but it's positivist in its construction.
Okay. So is this essentially a difference between the East and the West, or would it be more accurate to say that it is how the whole world has progressed? That even in the West, before, let's say, the Industrial Revolution, society was organized in a certain way, and even they had a lot of things in common with this. Of course, I mean, the very Hindu nature of polity in India there would be significant differences.
Right.
But let's say, the stress on community and how law was less about prescription and more about how people were living together,
right,
and kind of rationalizing that and making things work. Do you think there is more commonality back in the day?
I don't really think so, because if we go back, you look at the Christianity's interaction with Judaism, and they took Judaism. So Christianity was founded on the rationale that the crucifixion was like a canonical event, and they put themselves above Jews for that reason, and they kind of labeled Jewish law as very ritualistic and prone to idolatry, and mostly outlawing Jewish ritual was the founding basis for Christianity also at the time. And so then you're coming to this worldview that they label ritual as something idolatrous, which is man-made. And then Christianity comes to this, and obviously everything is biblical for them, and they are extremely prescriptive and injunctive in their in how they operate. So obviously that's why the Reformation took place. So it's very ecclesiastical, very centralized. So I don't think. And that's why that's why over the centuries the frustration leading to the Reformation built up. So when the Reformation did happen, again they did the same thing with the Catholics that the Catholics did with the Jews, which was kind of saying that Catholicism is like this. There's corruption in the clergy. There's the church is doing this, which is not. So then they separated law into into an eternal portion, which is given by God and cannot be changed, and into the secular realm, which is man-made. It's some powers given to the king to kind of moderate our existence on earth, that sort of thing. But again, when there's centralized power in a king, if you say a king can make any law, because that deals with the earthly realm, then you're giving the king a lot of power, and this led to a lot of authoritarianism. So again, it was not community-based, because I don't think any religion or any country was organized such a complex way as ours was.
Right.
With hundreds of languages, hundreds of sects within sects and sects, and there's a huge tree with millions of branches. So nothing was ever this complex to deal with. For the most part, Europe is like a bunch of states that were very racist towards each other. They're still racist towards, say, Mediterraneans. So again, they were racially grouping themselves also, not just us. Like now we see racism as white people against brown and black or whatever, but even they have internal racism as well. We have the Bosnian Wars, which were basically white Serbs and against white Muslims. So again, they were dividing themselves on various fronts, mostly either the church that you were subscribing to or race. So I think somewhere here, like there's a very complex landscape that's just not set up to be governed by a central power. I think leaving a lot to individuals, to communities, kind of makes it more organic also, because at some point people are not going to follow everything you say, and then it'll lead to a reformation. So does that make sense?
Yeah, I get what you're saying. The little that I've read about pre-industrial law in Europe, for example, I think that it starts with the Roman tradition of law, and then at somewhere around the 11th century, the Common Era, coinciding with their theological development also with Saint Thomas Aquinas.
Yeah, Aquinas.
He brings in he revives the Greek culture of questioning in the Christian tradition. And so he kind of merges both these streams. Christians, which is the Christianity, the religion itself, which is very dogmatic and, without any rituals and stuff like that. And then he brings in philosophy of the Greeks.
Right.
And so he kind of tries to reconcile these two things and synthesize the thing. And law also takes a parallel course and starts becoming professionalized. But the major disruption that I understand is when the Industrial Revolution happens.
Yeah.
And that is when things get really fuzzy. Because then what they want to do is that they want to make it possible for corporations to do business and to gain access to the natural resources as well as markets. So for doing that, they make corporations very powerful. They do that by empowering them through law.
Yeah.
And so modern law, in that sense, is an apologia for the corporations, for them to kind of maximize their profits and gain control of as much resources as possible. And so this is basically the view of that is expressed in this book that I read called The Ecology of Law by Fridtjof Capra and Hugo Mati.
Capra, yeah.
And in that he's traced this development. So I think we'll...
That's one way to look at it.
Yeah.
And similar, so if you think about kind of not just corporate exploitation, but if you think of the East India Company as a corporate company, which it is, and then it's directly linked to the state of the UK. So as to further state interest, how do you kind of manage this society? They did go to colonies and they exert influence through law, and a part of it is secularism, right? So what happens is in kind of avowing religious neutrality, secularism says, okay, now I'm going to lord over you because I am neutral and I'm equal towards all religions. Now that exerts like a sort of hegemonic influence over other religions,
right.
And other religions start internalizing what the Reformation and its principles that are embodied in secularism start to say. So then, in separating all of this, then you have a secular realm which you control. Right. So it is for economic interest at the end of the day.
Correct.
So this entire, it's rooted in kind of the philosophy that arose from earlier. You mentioned Aquinas and all, yeah. So Aquinas, Luther took Aquinas' work, and a lot of Protestant philosophers took his work and kind of reframed it to suit their situation.
Yeah, but the thing is that the journey of Christianity and the Reformation that happened, everything is so muddled that it's very difficult for an outsider like me or you to make sense of what they were really trying to say.
Yeah.
Because Aquinas was doing exactly the opposite of what Luther did. Because Aquinas was trying to infuse Christianity with a Greek spirit, with a spirit of questioning and philosophy, to make it more sustainable.
Right.
And Luther comes about and says that all this is nonsense, that all you have to do is to believe in Christ and that he died for our sins and stuff like that, and build a direct relationship with God, which is reflected in a lot of what the modern Hindus say when they say that, oh, we don't need to go to the temples because God is everywhere, and what is ritual about? How can the mother want the blood of?
In their defense, we also had the Bhakti movement. We had our own sort of a situation where all these people that were probably cut off from certain ritual practices kind of took things into their own hands.
Yeah.
Didn't deviate from the tradition enough to reject it and,
Correct.
But they still had their own, like say, the way Nama Siddhanta evolved in the Kaveri Delta. Right now, it's so ubiquitous that we already believe it. But at the time, if you think about it, Nama Siddhanta, which is kind of believing in the power of a name, you say the word Rama, you say Shiva, and that in itself has power. And when in saying it to yourself, you in japa and all of this, you kind of embody whatever the name embodies, right? So, and this belief is very radical because if you think about it, it's a big departure from Vedic traditions and Vedic philosophy.
I would argue otherwise.
No, as in what I mean is, you as an individual sitting separately from a huge ritual and saying the name, you didn't mean anything before that.
No, but the principle is the same.
The principle is there.
The principle is the same as the Mantra Shastra.
I'm saying they took it and took the freedom to do things with it.
Yeah.
Because again, economic situations, there's drought, there's famine, there's different kings, there's polity which changes and doesn't give certain the what is that called? Doesn't give what is it called when you like sponsor? It's patronage. So doesn't give the patronage to the right people and to continue their ritual traditions, whatever. So when these things are cut off, then you evolve and you build these philosophies, but that doesn't mean we use this as an excuse to stop following our own, achara and stuff.
Correct. I mean, yes. So you react to the circumstances.
Right.
And you develop new ways of
Right.
adjusting to
Right.
the new circumstances, so that you can continue that same
Right.
practice or the pursuit of the purusharthas
Yeah.
in your own way.
Yeah.
And there are different traditions that evolve out of that, and some of them are in conflict with the earlier traditions. No, conflict in terms of how the practice of that tradition happens, but at the core they are the same. And there is no they might have bitter polemics happening between different sampradayas, but at the same time both of them claim that they are
so they're still part of the whole. And again, even if there's a sampradaya that's breaking out, how would it evolve? It evolves within the tradition, and how as in it doesn't break away from the whole or the core.
Correct.
Say there's a new philosopher, say how Kashmiri Shaivism came about, Abhinavagupta and all of these guys. They had small schools of philosophy in the beginning, and as they found purchase over generations, as their disciples wrote commentaries and all of that, then it found a wider following, and it organically formed a separate sampradaya. But at the same time, that Shaiva text doesn't per se reject any of the core Brahminical traditions or any of the Vedic tenets. So that's how we look at it. It's part of the organic whole, even if it breaks off and does something new.
True. So which is not the case with how the Judo-Christian tradition seems to take that this approach. In fact, just while you were talking about it, it occurred to me that the Judo-Christian tradition is more like disproving that this maxim that two wrongs don't make a right. They keep doing everything wrong just to prove that the last mistake was the last.
Same thing with Islam. As Islam came,
it's the same.
Same story again, which is rejecting what
came before.
Christianity says, and this is the new Messiah now.
So some of the some traditionalists who value tradition, they seem to attribute the quality of tradition to Islam and Christianity also, which I think is a mistake, because by definition they are anti-tradition. They cancel everything that came before them.
Right.
In practice. Even though in theory they may say that they may pay lip service to the prophets that they had before, but they'll say that this is the final guy, and he's the only one that you should now look at.
So I think maybe what they're alluding to is the strength or the strictness of adherence, and maybe that's what they're...
Correct.
But again, we have a traditional core that has the same level of adherence and extreme commitment to...
I do believe that if there is... if you compare these religions with the Hindu tradition in its myriad forms, I do think that the Hindu tradition is way more demanding. And all this talk of, you can be anything, you can do anything, it just evaporates when you truly understand or you begin to understand what the tradition is. So talking of traditions, can you help us with understanding how the ancient system, as it was encoded in the Dharma Shastras, Manusmriti, for example, how that switch to modern law really happened?
So going back, first let's look at kind of how the Dharma Shastras are set up. There's about... Again, they all say that they are based in Vedic injunction, and they are all firmly rooted in the Veda, right? And then there's about 20 smritis. Mentioned the Manusmriti, it's one of them. There are about 20 of them, and all of them have kind of build on each other, or they are... So again...
Aside from each other also.
But they also contradict each other, and that's because you can't look at all the texts as being one consonant body. It's really not. What happens is there's an evolutive process. So Manusmriti is a little earlier than another Smriti, which is far more influential than Manusmriti actually on modern law, which is Yajnavalkya Smriti. A lot comes from that text over Manusmriti. or Manu Dharma Shastra, so Manava Dharma Shastra. So what happens is, in our tradition, commentaries are given precedence over the main text, and
the sutra themselves.
Yeah, and then oral traditions, customs, usages are given more precedence. So again, what is encoded in the text is essentially for the king to kind of get a lay of the land, to see, okay, these are these people, they follow a certain achara, these people do something else, this is recommended, and kind of give the king along with his administrators something to work with in framing their own law. So what would happen is there was always a contextualization process which the king and his administrators would take up. And these were all Dharma Shastra scholars, which the pedagogy is dead now, because we have essentially, because of colonial rule, we've lost the continuity of the Guru Shishya Parampara of Dharma Shastra scholars. But a few scholars still exist in India, but they are not of those lineages that we used to know. And so again, looking at the Smritis as isolated texts and then taking these texts as some biblical canons, that doesn't work. The entire thing is supposed to be interpreted by Dharma Shastra scholars and kind of made suitable for that time, that king, his intentions, the people that they're governing, all of that, because at the end of the day, it's based on what the people are like and what is suitable to them. So I think that's what's lost when we talk about there's so many diatribes about Manusmriti on the internet for no reason. It's just senseless. Someone takes a sentence from the Manusmriti, puts it out there, but that's not. It's not read in isolation like that. In fact, within the text itself, so Mimamsa principles of interpretation of text apply to the Dharma Shastras, right? So in that, Mimamsa kind of delineates. Mimamsa is for interpretation of the Veda, but it de facto applies to
all
texts in general, right, or the traditional texts. And so it delineates what is vidhi, which is injunction, what is ardhavada, which is an explanation, what is nisheda, which is something you shouldn't do.
Prohibitions.
Yeah, prohibitions. So, and then nama vadha, nama videya, something like that. So it's anything that's named. So
right.
They in the Vedas, if there's or in the Upanishads, if there's like a yajna that's described, then you have all of these portions to it. So this is how you take the text and interpret it. So these principles apply to Dharma Shastra. So I think if you randomly pick up a sentence from the Manusmriti, you don't know if it's a prescriptive sentence. If Manu says, don't kill cows, or you can kill cows, or there's animal sacrifice. In different places, he'll say killing of cows is prohibited, and in another place he'll say eat meat. Because different people eat meat,
but
and different situations.
But not cow meat, right?
Again, there's this entire thing about how earlier on.
Yeah, but that's not part of the Manusmriti.
It's not. So there's something called loka vidvish. Okay, there's a principle where you can again take something like beef, which perhaps was allowed in certain sacrificial situations, and then say because it's morally repugnant right now, it's not to be done. And that's what Manu and Yajnavalkya and all of them did, the commentators, because it's morally repugnant to society right now. We don't do it. It's highly prohibited. So I think just contextualizing all of these things is something that's missing. And then, the other thing is, there was also compendiums that were like compilations, subject-wise. So from all the Smritis, these commentators or Dharma Shastra scholars would take laws on a particular subject from all the Smritis and sort of compile them. And these were highly, they took importance over the other texts because they were very specific to the subject. They gave you everything you need. So again, these texts are not highlighted as much as the Smritis, which really aren't looked at that much or weren't looked at that much as these texts were or commentaries were. So like kind of a big picture. Again, Dharma Shastra gives a different type of it lays out the philosophy of the law. It lays out so many different things. It describes the people within it, their acharas and all of that. And then Arthashastra kind of gives you how to design the state around dharma, what the king should be doing, how polity is set up, all of these things. So they're read with each other, and they're read so as to set up the state with all of these principles embodied in it.
Right. So, I mean, what you are essentially saying is that people nowadays, when they think of Manusmriti or any other such Dharma Shastra, they think of it, they view it in the same way that they would view the Indian Penal Code today.
Yeah, exactly.
And they dumb it down.
Yes.
And sort of read stuff which is not exactly what the text is saying.
So again, going back to your question about how it was codified and all of that, textualism, we inherit textualism. Like I said, when Mimamsa principles are applicable, it's not pure textualism per se. Sanskrit grammar, Paninian grammar, or grammatical rules apply, and they're very closely linked to Mimamsa principles and hermeneutics. But pure textualism is a biblical construct. It's how they look at their text, which is unquestioning and all that, which is not how we look at our texts.
I'd also read a paper, and I don't remember who's the author of that, but the paper basically was about this codification business, and in that, the claim that the scholar made was that almost 90% of the Dharma Shastras were rejected at the time of codification because they were unintelligible to the British lawmakers.
Yeah.
Because, like you said, it consisted a lot of achara and prayaschit, these things.
Yeah.
And prayaschit for them did not make sense because clearly they don't do any prayaschit for
But they do have the principle, but they reject it in the framing of secular law. So again, in codification, looking at all these, first they couldn't make sense of it. Even the few Orientalists that kind of translated some Dharma Shastra texts and all, they just had translations. Again, they don't know how to read it because they are not traditionally trained in that pedagogy. So in reading it, again, literally, a lot is lost in translation, not just translation, but the worldview. And then in again taking the translation and then framing law with it, what they do is they leave out all the parts that, like you said, that describe ritual, prayaschita. There's another thing that Protestantism did, right? Rejecting ritual and then just simply separating religion and the secular spheres, and then you only govern over the secular realm. But actually, we know that everything is a part of religion, right? So anyway, so they kind of leave out all of these different aspects of it, and then they cherry pick what they want, and then you end up with a document that is nowhere connected to what you had before. It doesn't make sense to any of the. So a lot of Hindu Pandits, Sanskrit scholars were actually employed in the codification process. They all sat together. They probably well-meaning whatever, but they couldn't really do what the British man was asking them to do because they don't get the memo. Like they don't know what to do with a bunch of smritis in the sense that they know what to do and how to traditionally interpret these things or kind of make law within those frameworks, but that's not what he wants.
So would it be accurate? Sorry, please go.
Yeah, go ahead. No,
would it be accurate to say, if I make the analogy that when you make tea, right, and you pour the tea through a sieve, so the tea leaves are eventually discarded and you have the tea.
Okay.
But in this case, when Manusmriti was or the Dharma Shastras were converted into modern law, they make us eat the tea leaves and they throw away the tea.
So I think that's accurate. So again, the thing is, the law we have today, even the personal law, Hindu personal law, doesn't have much Hindu law embodied in it. It just, some parts of it are sort of vaguely based in Hindu law. So, for instance, we had these two schools, Hindu schools of law called Dayabhaga and Mitrakshara. So, Dayabhaga was predominant in Bengal and Mitrakshara everywhere else. And they took a kind of the joint family system and the co-parsonary and all of these principles from there. But at the end of the day, they didn't follow any of it because they changed the ideas of succession, adoption and maintenance according to British moralities and all of that, and they modernized and they added the element of divorce, which at the time of the Hindu Code bills, all the Orthodox, traditionalists and the Orthodoxy, they really strongly objected to it. So again, like it just doesn't resemble. Maybe some ideas are there somewhere, but they don't take the same form. Again, the joint family system has essentially been killed off because this is what the Hindu Code bills did. A lot of scholars at the time said it's a proper concerted attack on the joint family system, marriage, and the institutions. And also like P.V. Kane, he said he wrote the huge history of Dharmashastras, right? He took 40 years for him to write. Massive lifetime work. So he says at the time, this was a huge attack. It attacks the very core of how Hindu society is set up and organized. And he says that's the marriage and family and society are the reasons why we survived two colonizations. Like if you attack the core, you're going to lose your values, right? And so to some extent it did happen. Again, we prescribe more to modern values now. We don't know.
Exactly.
We can't imagine what it was like. So I'm not going to say good and bad because now it's already been done. But this is what they said at the time. This is what critics said. And actually at the time of drafting the Hindu Code bills, a lot of, like when it was tabled, it was invited to public opinion and stuff. And a lot of scholars wrote in heavily objecting to multiple portions of it. But none of it was taken seriously. Nehru had an agenda. He wanted to push the bills. And again, some people even said it's communal because you're imposing this on the Hindu population, but not doing it to the Muslim population. So a lot of different aspects, but we jumped way ahead. We'll go back a little to kind of 18th century and what the British were trying to do. Codify law, all the aspects. And then I mentioned textualism, which is one big issue. The other big issue is the concept of precedent. So we follow in common law systems. So we follow common law systems, so do other Commonwealth countries. And in common law system, precedent is at the core. It's the basic principle. And precedent is, or stare decisis. It is that court should follow precedent set on the same matter. If a certain matter is adjudicated this way at this moment, then in any similar case, the same rules shall apply. So that justice, this is their idea of justice, right? But to us, the idea of justice is a little different. We tailor justice according to the people before us. And that's something that is not just in the eyes of British law or common law. So, but if we think about it, so say, I think there was a case in Kerala during the British rule, but Kerala was still, I think, Travancore and all that. So there was a case of adultery brought before the king. And the defense was, in my community, we are allowed to adulter. So, sorry, keeping it PG. So, and then the king, and that's a valid defense, right? So, does your community do this? Maybe he'll just confirm with the rest of the community. And if he's allowed to do it, he's allowed to do it, even if it's not allowed for the rest of even if there's a criminal law that says adultery is punishable, he cannot impose it on this man because his community follows a certain. In the same case, a woman was brought because of adultery in Kerala, and she was also let off because her community practices it. Even like say visiting a prostitute, even if that was banned, like he could still argue within the bounds of his community and his law. So they have Kula Dharma and
Lokachara.
Yeah, all of that. So whatever your community does presides over everything else, which is not the case in common law, right? So if there's precedent and you apply the same thing to every case that you see, then you're going to get something where there's justice superficially, but not really, because again, you're killing off whatever they used to do, whatever their personal freedoms are. And it's not for us to judge as a judge what their community follows, right? So if you're gonna make it the whole thing, you make the whole thing uniform, then this is another thing about the modern liberal, neoliberal movements, which is the same thing for everyone, or it's not just.
Yeah.
And again, like this has evolved a little into egalitarianism, but it's just not the same when we're talking about religious law and kind of presiding over thousands of millions of different communities and sects and just a huge diverse landscape, right? So that's another aspect of it. And then another aspect would be so we discussed textualism, we discussed secularization and all of these things, and like putting aside ritual, prayaschitta and all of those portions. But they also undertook, in pursuit of the most authentic text, they would go searching for the oldest text, and they would regard that as the most authentic or the most traditional, and they would try and bring that in. But that's not how our scholarship works. That's Dharmashastrins will take the most recent commentary and interpret that into, and to make new law and to kind of interpret or give judgments and all of that. So in kind of putting aside our own way of looking at the law and interpreting Dharmashastras and the traditional pedagogy, they brought in an element that's alien to our own law. So again, just the entire worldview is different. The way, the philosophy of the law is different. So the two systems are incommensurate. So it's just not possible to undertake such a massive project. And
right. So it almost, it appears that what we were talking about just a while back, that the Judeo-Christian framework is anti-tradition, not tradition. And so if you compare that, this is exactly how it will play out in real life. That for them, going back to the oldest somehow is by default the right thing to do.
Right.
While we rely on the more recent ones, because it is a living tradition.
Yes, exactly.
And we realize that, over the last, let's say, 2000 years, people have worked out several interpretations of the original.
Right.
And that is the continuity we maintain with the original.
Right.
Let's say with the Vedic corpus.
Exactly.
And then the whole history of Dharmashastra.
Right.
And we're sitting here in the 21st century, we cannot teleport ourselves to the Vedic age. So we have a organic connection with that.
Exactly.
And that organic connection cannot be denied.
Yes.
But on the other side, it is just the opposite.
Very well put, yeah.
So you mentioned about, and this may be a slightly difficult question, but I suppose you're used to it. I've seen that on Twitter. So let's take the case of marriage. You said the institution of marriage was put under severe strain by the codification and by making.
I also said that critics said that. I don't know if I should take that position. I don't know.
No, that's
what
fine.
it was
No,
like.
that's fine. I'm just
I get it.
totally
I get
understand.
it. No worries. Yeah.
So when divorce,
the lawyer in me had to tell.
So the idea of divorce, when it was implanted in the Hindu code bill, obviously there was a huge reaction. But we know that in the current century, divorce is a fact of life.
Yeah.
It may have been accelerated or it may have been weaponized by the Hindu code bill, but yet there were marriages which were not doing well and falling apart.
Yeah.
So what do you think? what should have been the approach, if you can answer that? What can be how do you make the best of both?
Yeah, I think this is a difficult question.
That's why
that even courts, I guess, struggle with, because where do you balance these things, and so again, I think the easy position to take would be that again, if it's a top-down imposition, it may not be as organic. But at the end of the day, with passing time, if you can bring in some modern values, and if it's for the better, then a lot of people, like even in the same-sex marriage case and all, they will say that if the courts don't do it, and you're waiting for society to change organically, then it'll never happen. So at least this will kind of push the envelope and kind of force things into, even if it's forced, because again, it's for the greater good, that sort of thing. But I think at the time, marriage was looked at very differently. I think it was so sacrosanct for them. Again, even the Special Marriage Act, which allowed for intercaste marriages and interreligion marriages, was unthinkable. So a lot of traditional scholars opposed that as well. So, and again, I think my point is, in the marriage rules and in the Adoption and Maintenance Act and the Succession Act and all of that, they kind of, I think the veneer of being based in Hindu law is there, but it's modern law. So I think one thing would be, first, just call it what it is. Like, let's not use some terms here and there and then say, because there are so many different, Kerala has matrilineal systems, and so all of these things were phased out in one go. In Kerala, marriages, the matrilineal system, the Nayars and all, they have a very interesting system of marriage. The woman marries someone or a man just for children. She takes care of the children, and once the children are born and being raised and stuff, she can just let him go, and he can leave the home. Like, it's very woman centric. So these marriages are unthinkable. One may even say that it's immoral if a man is walking in and out of that woman's home. But that's not what it is. It's a warrior tradition, and they need Nayar warriors. So it's set up in such a way that it is conducive of the needs of the time, whatever the Kshatriya men lived a certain way. So if the Marriage Act kind of strikes this out in one blow and says this is criminalized or whatever, then that becomes a problem. So I think this is a problem where not enough attention is paid, and not enough. First, no one has all this information in one place. That's another big issue. Like, we have castes of India and big compendia, but they're all some surveys done by some French anthropologists in 17th century. They're so outdated. Depending on those to sort of make these laws even on missionary literature. And see, most of these guys, Muller, Hastings, they all wrote on Hinduism, translated things. They were all reverends, their missions. The background of it is such that they are not trying to actually just report what is practiced, but they obviously come with a lens and with a worldview of their own.
And with an agenda.
With an agenda, absolutely. So I think looking at these while framing these laws would have been the right way to do it. And also kind of giving some flexibility would have been nicer. So again, I think I would say that even in introduction of divorce, the courts have been pretty conservative, if I say so, because it is a social institution, and I'm sure the judges then, even now, many judges are conservative. So if you think about it, they did preserve some aspects of it. So, there's this 6-month period where you have to attempt to reconcile. There's arbitration or mediation, rather, sorry. So there's a lot of these processes so that it's not like an immediate divorce. They make the period protracted a little bit so as to Just give it a room for reconciliation in case there is any, and unless the grounds are so obvious and plain, I think so. So in reading a little bit of distance into it, or the courts have sort of made divorce law a little, they softened the blow of it over the years, in my opinion at least. So I think again, like I won't take a yes or no stand, but I guess we can, I think looking back, maybe it could have been envisioned, maybe consult actual experts, Dharmashastra experts, or community consultation was basically ignored. So doing it a certain way, involving community participation in the legislative process is the right way to do it, and Nehru did not do that with the Hindu Code bills because there was frequent opposition over the years. He attempted to introduce them in the 40s, and again it was tabled, rejected. So I think he just wanted to push them through no matter what. And I think that's the issue, where you just push through without the proper democratic processes that kind of bring in all of these elements. I don't know how much they would have actually implemented. But still, again, like at least having those voices for us to read and look back would have been nice. So I think maybe I want to look at it from that lens.
Right. Yeah. Because the kind of stories, the anecdotal evidence that we have whenever someone goes through a divorce, law is for sure being weaponized to destroy the institution of marriage. Yeah. There is no doubt about that. And you have a whole machinery of lawyers and, you know, then manipulating facts in the case, and then, you know, informing them how, we were just talking about it before, that you have to, they teach you to lie to gain maximum benefit from the proceedings and so on and so forth. So in that sense, law as it is practiced today is very adversarial.
Yeah, true.
And I suppose we'll touch the customary law in another podcast. Yeah. But customary law does tend to have a more reconciliatory approach, where the whole community gets involved and, you know, tries to work things out.
Yeah.
And community pressure is always, it's soft coercion, as opposed to, you know, some hammer being, struck.
And honestly, public morality, societal taboos are what kept our moral codes alive, in opposition to the way the church operated. They tell you have to fear hell if you do adultery, they have to fear the burning, whatever, and they describe hell in so many different ways. You know, Dante's 7 layers of hell and all that. So again, they force coercion through fear and kind of the consequences and all of that. Whereas in our society, morality for the most part was enforced through the community not being okay with certain things, and then you don't want to risk kind of the society's displeasure. Yeah. So again, so it's kind of like, okay, I want to do it, but I probably won't because I'll be outcasted or outlawed, whatever, or it won't gain wide acceptance, and it makes it hard to live in the community. Now we have insular families, very individualized, nucleated groups, and in this setting you can basically do whatever you want, and there's no community for that keeps a check on your morality. So we see so much.
No, in fact, it is a vicious circle.
Yeah.
Like the concerns of the traditionalist scholars that you mentioned were definitely not unfounded.
Yeah.
When they said that, this is a slippery slope.
Yeah.
Because once you allow that concept in law, the concept of divorce, which was unheard of so far. So that once you allow that to sneak in, then it will take a life of its own.
Right.
And then it will have a vicious circle effect, and things will start getting from bad to worse. And that we've seen over the course of the years.
Yeah.
But the tricky part is how do you still address that problem without letting it devolve into how it has. Which brings me to a question I wanted to ask earlier. We've spoken so much about colonial intervention and the effect of Christian or the influence of Christian morality on law today. What about the Islamic period? Do you have anything to say about that?
So, for the most part, they left us alone in the sense that there would be some Brahmin Pandits in court or wherever it is, and as long as the issue was settled, they didn't really care which law was applied, because again they didn't interfere in Hindu law and really take it, and they didn't try to do anything with it. Either they ban it and they want to impose their law, but they don't really go in, snake their way into scholarship and force them to do something they don't. So for the most part, they were actually left alone. The Dharma Shastra, Guru Shishya Parampara and all of that, a lot of Dharma Shastra scholars lived through Varanasi. Even now, the only ones that are there, I think they're in Varanasi. So they lived through Islamic invasions and all that, no matter who was at the center. Again, some processes, some things were left alone for. In fact, if you think about, if you read, I was reading somewhere this very interesting. I didn't read the whole paper, but I read the abstract, and they were talking about how, like, the Sringeri Mutt and all of these, they were still operating during Islamic rule, and the mathas were all centers for dispute settlement and adjudication, and they would apply Dharma Shastra and resolve disputes. So they acted as courts in a sense, and these were mostly undisturbed. I think when the colonial powers came in, what they tried to kind of control the political sphere. So there's another thing about even temple control. Okay, I'm not going to go into that now. But yeah, for the most part, I think they were left alone. In fact, in many places, Hindu law was the dominant law, and Muslims were obviously lower in numbers, so they also followed whatever law was prevalent there. So there was no attack as such. I think our systems remained intact. Maybe our temples didn't, but systems, I think, for the most part, did. In certain places, obviously not, say in Kashmir, everything was killed off because they killed most of the Brahmins, the rest of them fled. So those places are exceptions. But if you think about, broadly Mughal rule, again, it was in certain areas for certain periods, and a lot of places were kind of untouched until the British came in, like, say, large parts of South India and all of that. So I think for the most part, our legal systems were intact through the Islamic rule.
Right. So then coming to contemporary India, there's a lot of talk about uniform civil code. And given all that we've discussed, how do we place the uniform civil code in this long trajectory?
Yeah. It's embodied in the constitution that the state should strive for a common code for all the citizens. I think it's Article 44. So in some ways it was a project of the British, but also like a continuing project of the modern Indian state, and it was done for the Hindus. It's by no means comprehensive, and it may have been imperfect. We've discussed this, but it has been, or the Hindus have been subject to it. So even at the time, I mentioned the critics of the Hindu code bills, and they also said that it was a communal law. They're saying you're imposing this on the Hindus but not the Muslims. So they were also kind of pissed off about that as well. And in some respects, I think I think if you're going to have Hindus subject to a certain code, then maybe you can apply to all the citizens. I know that Hindus get the wrong end of the stick when it comes to the Indian state because, all of this temple control and all of these issues. But yeah, I think it's at this point, a lot of Islamic countries also have leaned towards, towards codification of personal law. For instance, Turkey, even some laws in Pakistan, they've codified their personal law because how else do you adjudicate? Because right now, most of the most of their civil disputes are settled in Shariat courts or their personal courts. So the Indian courts don't have anything to apply. So if you want them to be able to approach courts and give them certain legal rights and remedies, especially for women, because they're often stuck in marriages or whatever. And so again, Muslim women's rights groups really want this change. Probably the orthodoxy doesn't want to see it because it's obviously ceding territory to a lot of different modernity and all these things creeping in, and for them, I think there's this misconception also that Hindu law isn't as tied to religion as the Islamic law is, but that's just not the case. It's just that we were separated from it and they haven't been, so you see it intact. But again, I think since the government's doing consultation, I think it's a purely political project. I think they just want to do it right before 2024, so that there's some veneer of having done something to the Muslims, not for, but no, it's not really for the Hindus, because we are unaffected. If it doesn't involve Hindu law and it just involves the application of broad principles of marriage, adoption, these are the main areas again: marriage, adoption, succession, maintenance, divorce. So these, if it's just an application, extension of these laws to the Muslims, then I don't see too many issues with it. So I think that's where I'm at. That I think it's sort of harmless. Even after these laws pass, I'm sure a lot will operate under the under the blanket anyway, because again, these Shariat courts aren't going to go anywhere. They're going to impose Sharia. They will not care for the rule of law. And that's how we've seen it anyway. So I don't know how much effect they'll actually have. I think we'll have to wait to see what they actually do. But I think this is the broad plan, because again, they had these consultations, the law commission and all. And it's mainly about kind of bringing in these personal laws and applying them to the rest of the population, so that Muslim women can actually approach courts for various divorce maintenance. Maintenance is a big issue, because if there is a divorce, which is often unilateral, they're not entitled to maintenance, and they're often not allowed to work also, so they don't have their own livelihood, which is not the case with Hindu women. Hindu women often support families and they're out working, they do a lot of things. So I think because they're self-sustaining also, like, they have more freedom, but which Muslim women really don't. So I think it's really crucial for them to get these access to maintenance and have the court enforce it, so that they have some remedy.
Yeah.
Because Shariat courts will not give it to them. And I think that's the issue.
Yeah, my interest in Uniform Civil Code is kind of tangential, because as you rightly said, it does not really make a difference to the Hindu community now, because we've gone through that.
Yeah, we've gone through
70 years ago. And like Sai mentioned somewhere, he had said that Uniform Civil Code is a loser's argument.
Yeah.
And I do agree with that. But whatever kind of argument it is, it's only political, as you said. However, at the core of this whole debate is something which is very serious, almost existential to and very crucial to our well-being, which is, how do we, given that this is the trend and this is the nature of modern law, which we've been talking about, where it has brushed off everything that was Hindu in law, in how society was governed, and how people conducted themselves, and what kind of punishments and what kind of self-correction mechanisms were there. So all that is gone. Now you just have this law and you have to deal with it. So let's take the case of something like Sabrimala. The arguments will go on endlessly. There will be petition, there will be counter petition, there will be one judgment, there will be a revised judgment. All this, I think this will go endlessly. But the question is, how do we prevent another Sabrimala from happening? What is the preventive mechanism? Not corrective. Corrective, we know that there is a petition to be made. We've been through that enough for the last 20 years. But does that involve correcting the jurisprudence itself? that you go into the theory of law and deal with it there, so that how you think about application of law is corrected. So do you have any thoughts on that?
So, first of all, I feel like Sabrimala type situations happen every day. If you think about the number of shrines that are under government control and the number of orders they pass relating to so many different administrative topics, they just exercise absolute free control. There is no checks. There are no checks on the sort of actions they take. Because Sabarimala is so precious and close to the hearts of Kerala Hindus, they actually went on the streets and protested this government action. But I think that is not happening in other places. So we don't see the magnitude of the changes they're making, but they are happening. Across Tamil Nadu, across Andhra Pradesh, if you take just the day-to-day activities of TTD, I think we would be really shocked. I think literally the entire country should be out on the streets, but just doesn't happen. So the minute that the temples are ceded to government control and you're giving them, the acts and the constitution says a state cannot interfere with religion per se. They can only preside over the secular aspects of religion, which I don't know what, that's meaningless. If you take, say, a temple buying flowers and you want to let the government control it because the government says, oh, buying flowers is transactional, it's economic, it's nothing to do with the temple. It's purely, but that's not the case. It's the temples across India each have their own, florist communities that are dependent often on the temples. They're generally locals who supply, and all of these.
And even the choice of flowers,
all of these castes that are actually dependent on the temples are killed off when the state says, oh, I'm going to throw out a tender and my family can auction and can throw in their name in the hat and get some tender to supply flowers. And then things like there's a lot of controversies on temple supply of, say, vegetables and all of these things to temples, and they're tainted, they're not, so again, when this happens as an economic transaction, but it's for God, we look at it very differently, right? The person supplying it would look at it differently. If it's for a temple, our communities, our people would look at it differently. But if this is just an economic transaction and it's looked at, so even simple things like this, I feel like the government shouldn't be doing. So if you really break it down and think about the amount of power that they're given within the temple structures and the administrative structures, it's shocking. And I feel like we would actually be on the streets, which we are not, unfortunately. But from the court's perspective, I feel like there's little we can do. I think you just have to have a judge that's apologetic to your cause in some respects, because there's this book called Religion Under Bureaucracy. It's by a political science scholar, Franklin Pressler. He in that first chapter he gives an account of the temples in Tamil Nadu and the control of temples there. So in the first chapter he kind of says that it's nothing that we haven't stated, but he says it very well, which is when the modern state was conceptualized, now you have this country to rule over, and it's kind of inevitable, or it's a fact that religion and law are very, very interlinked, and political power stems from kind of exerting your sphere of influence. So there are these institutions, these religious institutions that have had a sphere of influence since time immemorial, and people only kind of care for what the religious institutions do, say for them, whatever. Because again, they were centers, and they were kind of the state, if you think about charitable activities, just shelter for people, just all sorts of different activities. In a sense, it's all the tasks that a modern socialist state undertakes. So if you think about it that way, then religious institutions are a sphere of influence. And as a political body that is separate from this, then where do you exert your influence? People are going to ignore you. So in order to kind of grab political power also is the control of religious institutions. It's economic, obviously, because again, you have all these properties and assets and wealth that you have to manage. So it is economic, but it's extremely political, and no one wants to kind of cede their political power to any institution. So I think this is where it comes from. And then once you've given that control, now the state basically does what it wants. If you go to so many different temples, I went to one Tamil Nadu recently, but and the priest was saying that they just issue orders saying whatever they want, like especially the government now. There's been a lot of controversy around that, but they basically exert their anti-Brahmin agenda. They exert their political agendas through temples and by showing their might. So they arbitrary orders all the time. Who know, some of them are being challenged by some activists, but how much can they really do if this is what the state is intending to do, and they have all this apparatus in place to do it with? So I think Sabarimala-like situations are unavoidable. In fact, we have the annual sacrifice issue, and they banned it. So where in many states it is banned, and the state's law takes precedence over local customs, right? So again, they found ways around it, like say, if you take a goat to a priest from the back, he'll make a little cut and then you sacrifice the goat somewhere outside the premises. So there's a little, like, we're working around it, but when the state really does certain things, I feel like all of these need to be Sabarimala scale issues, but they're really not.
Yeah.
And again, I think someone sympathetic to your through the courts, little can be, it can be challenged, but you can't take back what you've lost through the courts. It's difficult.
True.
Does that make sense?
True. No, at the heart of the issue is the fact that the relationship between law and society is circular.
Yeah.
It's supposed to be circular. But we are increasingly moving towards a scenario where law has pushed society into a corner. And now it is only the law which dictates agenda, especially when it comes to religious matters. And over time, when this goes on for a long enough time, then it becomes part of culture itself.
Yeah.
And temple issues and rituals like Pashu Bali, they have been under duress for so long. They've been marginalized and they've been demonized to a point where it has now been internalized by Hindu society itself. Yes, true. So now, like you said, that Sabarimala was a special case where people came onto the streets and made their point. But that is not going to happen for the case of Pashu Bali, because most Hindus
morally
now
repugnant to. So they just think it's. But again, it's not our place, because if a certain communities thinks that Pashu Bali is a center for their.
No, in fact, this was a mainstream view earlier that Pashu Bali is supposed to be given.
Yeah.
Now we have come to a point where it has become marginalized.
Yeah.
And we are now pleading for saving that marginalized. Who the minute or the minority, a small minority of practitioners who do follow such rituals, please give them their rights.
Yeah.
So we've come to that point.
And there's just a few temples, honestly. I don't understand
that's
the
what
point
I'm saying. So now we are begging the state for mercy, that we are only some small bunch of people, please let us be.
Yeah.
However, this is a mainstream practice. This comes from the Vedic era. And of course, in Tantric Hinduism, it's the fundamental practice. And if we go through literature on the act of animal sacrifice, we find that it is so religiously significant. You just cannot do away with it.
They even had human sacrifice.
No, of course.
But we're not getting it.
So that's an argument that they like, what happens if they...
I know. No, I'm not going to do that. I'm just...
yeah, of course.
But so this is huge, right? They should, if a practice is threatened, people should be protesting, and the state really can't do anything to enforce something which the people really don't want. So, for example, when they tried to ban Jallikattu, entire Tamil Nadu, it's just a few villages that practice it, but they were all up in arms. They resisted very hard.
Absolutely.
And the Supreme Court had a judgment, but they asked the states to revise their rules on animal cruelty and all of that, and they allowed it as long as certain cruel practices don't take place, and try to regulate it. But at least something like that, right? Like if you want to regulate, they want to regulate everything, but at least an outright ban is just ludicrous, right? So, but again, these are most temples in across India, but most of the temples, the ones with wealth at least and influence, majority of them are Brahmin, which is why it's okay to do these things.
Right.
If you think about, say, there's a massive Mariamman temple near outside of Trichy, and that's also under government control. So back then, there were certain priests of different communities there, but since those lineages have been lost, now there are Brahmin priests. But essentially, it's a Mariamman temple, which is a local deity. And if something actually happened there are big politicians and all linked to those temples of non-Brahmin communities. They would not stand for it. So again, I think it's the power of the community also, which is not being seen. Which is another reason why incursions like this happen on a day-to-day, and which there should be. Again, in the context of animal sacrifice, also I want to mention that American Supreme Court judgment, which America has a very different view of religious freedom. There, I think it's far more religious freedom than we are afforded here. Because again, here, because it's so complex, because everything is so religious, I think the state takes it upon itself to be very paternalistic, to regulate more and go into the private sphere and really regulate everything. But in America, there was this church. It's called the Church of Lukimi Babalu Ai. So it's a Santeria religion. Basically, Santeria is Catholicism plus some elements of like African folk religions and stuff. And it was like kind of from West Africa, but though that community went to Cuba and came to America from there. This was in Florida, I think. So these guys have a practice of animal sacrifice. They were wanting to, I think, set up a new church. And the local administration there passed an order saying sacrifice for explicitly religious purpose, not for meat consumption, whatever, is being outlawed and stuff. So these guys, obviously, it didn't mention them, but obviously they wanted to regulate a practice that they saw as morally repulsive, and they don't like animal sacrifice. So
they don't have
as in
the meat after sacrificing?
That's what ritual sacrifice is, something that everyone finds fault with, and not meat consumption. The meat industry can like push a cow through a conveyor belt and like it comes out in pieces, but everyone's okay with that. Right. But we're not okay with ritual sacrifice for some reason. So this church, so they went to the Supreme Court, and Supreme Court said this is a religious practice that the order clearly challenges. And again, they have the Establishment Clause, which is the First Amendment. It says to the Constitution, it says that the state cannot in any way be seen establishing or like supporting a religion, nor inhibiting it. So you can't go after religion. So they have religious freedom is more, it's sacrosanct in some respects. Again, you can, America also has the freedom of, you can declare a certain, you start a small like sect, or you build a following, you can declare that as a religion, and they will give you the same rights that other religions have. So which is not the case in India. So and that's how like there's so much evangelical nonsense going on. But whatever, that's besides the point. I'm just saying, I think our idea of religious freedom really needs to change, and not just ours, but the court's idea, and how far you can actually regulate an already privatized religion. Much of our religion is relegated to the private sphere already through the secularization of law and all of this. And if you think about it, state patronage for so many festivals has died out.
Correct.
Randomly, I was in the library the other day. There's a book I really love called Gods of Ritual, Gods of Stone. I saw the same author's name on the book, so I just opened it up. It's about like state and colonial, or like Indian states and the colonial interaction and a kingdom. Joanne Waghorn, something like that.
Okay.
I forgot her there's a middle name also. But I think Waghorn. I'll send it to you. And then, so randomly I just flipping through. It's like a It has a lot of pictures and images from that palace and all of that. I think it's somewhere in Tamil Nadu only. And it described like a Dasara procession. It said Dasara was very pompously celebrated. And it's died out now because of the lack of state patronage, clearly because of colonial rule. So you just kill off public religion. That's
Correct.
been the aim. You just kill off. Like Ram Leelas aren't taking place, and we see even Ravana effigies. We see it here and there. No one cares.
Right.
And same with some festivals in South India where they're all being delegated to the private sphere, and so this is like one of those aspects of exerting control over so many different aspects. So I think somewhere the idea of religious freedom really needs to change. What is it to be truly free?
Yeah.
And as long, again, we're not saying we want absolute rights to anything, because we can't if there's a state. But it just needs to expand and think about. And now we have so many different countries and so much access to so much literature from other countries. I think it is unthinkable for someone to like type and get US Supreme Court judgments back in the day. So I get that they don't understand religious freedom in the same way, but now there's no excuse for courts to interpret certain things in certain ways. And again, it's a very paternalistic agenda. They all see themselves as moral arbiters of religion. They see themselves as they take the freedom to interpret religion as they please. They interpret scripture. So again, even when the Hindu code bills were being passed, some critic said this is like the devil reading scripture to suit his own needs, right? Like, so if a devil reads scripture, he's gonna take from it what he wants, and that's exactly what our courts do. Our judges sit there and do whatever they want. So again, another judgment, one of the judgments that I read and actually analyzed was the judgment. It's called Shastriya Purushdas Ji versus someone, but it's basically the Swaminarayan sect case. They said they want Hindu were a separate religion, so that they get rights, right, and they can be outside of government control. But the court said no, you're all. They looked at what the believers, what they do, how the temples are set up, and they looked at literature and all. They're like, oh no, you're just as Hindu. And then that was the first judgment in which
it reminds me of that meme which says कि तुझे नहीं पता तो लेकिन
like तू है. That's so funny. So exactly. So they do this for everything. Like I mentioned earlier, they do it to caste as well. They have an idea of caste which they impose through the courts. But this is about Hinduism. They said, what is Hinduism? And tried to define it, and that's the first place. Yeah, exactly. But way of life thing came before. It was like, I think Radhakrishnan and all had said such things before. So again, this is a very, I don't know if I could call it Vedantic, but very like, I don't know, Protestantized view of religion, which is, again, I don't find fault with them. It's just that looking back, it's not encompassive or inclusive of any of this. And everyone talks about diversity and inclusion, but they don't talk about inclusion in such things. So again, they looked at Hinduism, they tried to define it, because again, it's not a particular thing. There's no definition. And I went through the judgment looking at just the citations, who they cited to build their idea of religion. And the first name is Monier Williams, who obviously was a Christian missionary who came in initially. Muller, who was another missionary, and who came with the intent to convert. So I'm reading your text so that I know where to attack you from. And also, again, a lot of this missionary literature was also used abroad to raise money. So you'll find, this is a tangent, I'll come back in a second. It's very interesting though. You'll find these colonial commissioned little booklets, or not little booklets, but like booklets of Hindu deities. And they were like paintings, and they were generally commissioned. It's called a colonial school, but generally they were commissioned for various topics also, not just deities, but also like castes and all. You'll find a lot, like there'll be a potter and then just he'll draw them, and there'll be a weaver and he'll draw it. So just kind of these images, and then especially of deities, these images of Hindu deities to them are somehow very comical. They see Ganapati and they see the monkey god and they see all of these things. These are very
Funny to them.
funny, not just funny, but like repulsive. So like these are idolatrous, base, uncivilized, and to kind of drive this point home, because there was no internet back in the day, these paintings were commissioned and then they were taken back by the missionaries to Britain, Germany, wherever they were from, European nations, Portugal, whatever, to raise money in their elite circles abroad. So they would flip through and show them, oh my God, look at they need Christ to save them. And then this is how they would raise money to actually convert. So this is the lens with which these missionary scholars are coming from. They didn't learn Sanskrit because they love Sanskrit and they think Panini is a genius. That's not what they're doing. So I think knowing these things is essential to using these texts to actually say what Hinduism is. Like, do you not have a single practicing Hindu scholar who's a Sanskritist to support your judgment? And of course there was English literature written by at least Indians till then. They did cite one of Radhakrishnan's work, but there was a lot more. You don't have to start with Monier Williams and Muller and Hastings. Hastings was a reverend. Just clearly it says Reverend Hastings. So why are you using Reverend Hastings to define Hinduism for you? Why are you doing this? And the craziest part in all of this is the judgment is authored by Gajendra Gadkar. Gajendra Gadkar is a Dharmashastran scholar himself. His father was also one, and he learned Hindu law. He wrote a few books on Hindu law. He translated Arthasangraha, which is a Mimamsa text. So this guy comes from a tradition of scholarship. He knows Sanskrit himself. And he is using these guys in his judgment to talk about what Hinduism is. It's just nuts to me. It's nuts. And even now, if you go back to the Shirur judgment, actually not the Shirur judgment. It's the Shirur judgment. So in that there's like denominational rights and all of that. So to define what a denomination is, they go to the Oxford Dictionary. Do you have to go to the Oxford Dictionary? And also, denomination is not the same as a Christian denomination. It's very different here. It's a sampradaya. So again, I think the Hindi version has the word sampradaya. But even in kind of explaining these things, you find you're writing a judgment, you want to use... First of all, you shouldn't be writing judgments about this because no one died and made you king. But if you are, then at least use something that actually represents, or someone or a source that actually represents what the practice is and what the practicing Hindu would do or say in that matter. And I get that there's like thousands of sects and you can't really pick one, but if you're going to give denominational rights to all denominations, why don't you consult a few? Where is the cultural consultation, and where are the cultural experts here who, and when there's stuff like, say, forensic expertise, they call in a, so when they need expertise in other areas like scientific fields and stuff like, say, fingerprint analysis, forensic evidence and all of that, they do call in experts. So it's not like it's unheard of for the court to be calling an expert and, making a judgment, but they don't do it. They should be consulting practitioners. They should be consulting and not just, and the public at large sometimes if it's warranted, right? So I think this sort of very, very narrow view that they have, and again, the like I said, they want to lord over everyone. They want to infuse their own morality into it. They want the Indian modernist state, and they have a very reformist agenda. And that comes through in their judgments. That comes through in whatever they do. It comes through in state practice when it comes to regulating a lot of. Look at the Diwali, the firecracker ban in Delhi here. So this agenda is apparent in all of their...
Delhi firecracker ban is not even scientific.
It's not. I know.
They've junked the scientific paper also. It's amazing that...
So I think they've used the help to... Again, they view it as...
The judge has actually said that I don't need a scientific paper to tell me that this is bad.
Oh my God. So. But what about stubble burning?
Yeah. No one's going to answer that. No, so I get what you're saying. and what we were discussing before that, how law influences society, and now after all these decades of living under this kind of a legal system, the society has also undergone a change.
Yeah,
and
true.
It cannot be attributed only to the legal system, but also to so many changes, the economic
Western
pressures,
influence.
and technology, all that, information boom, all kinds of stuff. But all said and done, the society has changed and is changing even more rapidly as we speak. To maintain the sanctity of religious tradition, which is not, as some people believe, anyone can have a go at it. That is not how it works. Something has to be done to educate the public also, right? We were talking about, why they don't consult enough experts, but I think that as we go forward, the number of experts will keep
dwindling. Right.
And even to find an expert, you'll have to send a mission. so that is not going to happen. Which means that there is an urgent need to educate people and to encourage scholarship in these matters, so that you have genuine traditional scholars.
Yes.
Maybe empowering the mathas and various sampradayas, and pushing reform in that direction. So one of the demands from the Hindu side has been this the amendment of Articles 26 to 30.
Amendment to what?
Yeah, so basically, what they're saying is that these are inherently anti-Hindu articles, and that they are not conducive to the practice of Hindu religion, and they're making it more difficult. And they cite the same reasons that we just talked about. For example, Article 28, it does not allow government-aided schools to teach religion, or
religious
even
instruction,
or even So what is classified as a religious instruction? Let's say something like a text like Mahabharata, which may not be exactly religious, right? There is more, if we can make that distinction, there is more moral philosophy in it than there is mention of gods and goddesses.
Okay.
So, and that is part of our civilizational heritage. But by looking at religion in such Protestant terms, what you have done is that you've classified that as a religious text and you've kept it away from people. So you are alienating society from its own knowledge traditions by imposing this view of secularism. In fact, just a small digression here. There is a tradition of critiquing secularism outside India, it seems, which unfortunately is not the case in India. Like, for example, there is this Canadian legal philosopher, Ian Benson, who has done some work in classifying the various kinds of secularism. Because secularism as such, the defining feature of secularism is this artificial division between the
state and religion.
between the private and the public sphere, and all that. How it manifests in legal terms is a matter of speculation. It can happen in various ways. So he defines, he further classifies secularism into positive, negative, neutral, etc., etc. And what is the relationship that the state has with religion? It could either ban all religion, or ban all public manifestation of religion, or it could encourage all religions equally, right? So that is not defined. When you just say that we are secular, are you saying you are rejecting all religions, or you're saying you're accepting all religions? Because both problems are both the views are problematic.
So if it's framed as like equal distance from all religions.
And
sort
is
of
that even possible? Because Jacob the Rover, for example, in his book, he clearly shows the design faults in secularism itself. So this is such a dense debate that no one is going to, I mean, the public is not going to engage with, at least, or the news channels are not going to engage with. But someone has to bell the cat.
Yeah, right.
Now, coming back to the articles, do you think that any such step or advocacy of amendments of this kind would help the cause?
I'm not so sure because, first of all, constitutional amendments are extremely difficult to do. The courts will just strike it down. There's judicial review. So I don't think our courts will uphold such things, with that too when done with the clear intent to expand Hindu religious rights. I think if we kind of actually demand, enforce, and get existing rights under the constitutions that other minorities do, that's plenty for us. It's plenty. We have enough resources, people, institutions in place to actually make a massive difference. So I think it's just not needed. It's a fight for something that won't make much difference. No matter what the constitution says, again, the court can say something else, which is, like I said, the Article 25, 26, the religious freedom, it's subject to reasonable restrictions, which is any fundamental right is subject to. And the restriction in this case is subject to public order, morality, and health. So if you say public order, you can read into it so many situations, and you can again take these amended constitutional rights and actually read in anything else into it. So does it really make a difference? I don't think so. I think those resources would be best spent kind of actually establishing institutions of religious instruction for Hindus. That's not banned. Just as minorities have so many different, churches have Sunday school and so many different, even in madrasas, there's so much religious instruction for children. They learn to read and write Arabic and stuff. So why don't we have you just divert the resources to setting up institutions for religious education for Hindus?
Provided there are resources available in the first place.
If you're gonna take resources to rally for these things, there's some resources at least.
Yeah.
What I'm saying is, or you can use that platform to raise money.
Right.
And kind of talk about the importance. So there's the same importance that you're talking about of these amendments is directly in correlation with the lack of a religious education but why do we want to fight for religious education in government schools? What difference would that make? Why don't you just start your own centers? Yeah. And make the architecture so it's pervasive. We can do a lot of different things now, especially with technology. We have different ways to reach people. Televisions, you can start a program for kids, maybe. I don't know. There's so much to do. Right. I feel like asking for constitutional amendments would just amount to nothing, maybe. First of all, I think they'll be struck down. Look at the protest for 370.
Right.
Massive protest. That's a constitutional amendment. It's very difficult for a government to actually stand after making such a massive move. Now it's in the court for judicial review, and they may strike it down. Although after this long and after the implementation of it may not have too much difference, but they can strike it down. So even years after the amendments are made, they can be struck down because our courts work slowly. So who knows? So what is the point? Again, look at property rights. Property rights are subject to a lot of restrictions. The state can basically take your property if they want it. It's encoded within property law and case law. So what difference would it actually make? I think that's what we would ask ourselves. If you really want rights for Hindus, fight for the existing rights and fight for the same rights that other minorities and their institutions have. Not just religious institutions, educational institutions, everything, right? In a sense, they're not taxed. And Hindu religions, in a sense, are taxed through government control because they pay a 12.5% administrative fee to the administrators that are present, plus they pay their salaries and all of that. So actually fight for institutional rights and you'll get so much more and you'll get further probably than any amendments can get you. And constitutional amendments happen at the very, very top. Is it really going to percolate and give us something substantial? That jury's out on that.
No, I do agree with that. I think that the state itself is too big a beast to tame now for the Hindus. And since we've had very little contribution to its growth, I think we should leave it alone and and try for it to leave us alone, and kind of mobilize resources and ourselves in the service of dharma outside of anything to do with state
And politics, please.
and politics. Yes, yeah, yeah. I mean, one could argue that this is also politics, but I use electoral politics.
Yeah, got it. Yeah, that's what I meant.
Yeah, absolutely, because that's a colossal waste of time.
Yeah, and it just gets us nowhere.
Absolutely. I think we can, this conversation has to continue, but given the time constraints, there are several open threads that we have right now, and I think in the further episodes we will take that up.
Okay, sure.
So I would like to conclude it for the day, and thank you.
Thank you for having me.
Yeah, thank you for coming. And just for the interest of the viewers, I think I should mention that we will, take ecology and law. We'll take customary justice forums and things like that, so that this could be a more informative, exchange of more informative conversation. All the information coming from you.
Cast. We should take up cast.
We should take up cast. So we have a lot of common interests, and we'll definitely take it forward.
Done.
Thank you so much. Thank you for coming.
Thank you so much.